is nothing more than a collection of objects, private property, to be used and even destroyed at the behest of the owner. The result is that Western society inherited a dominant worldview with these key premises. Human beings are not part of the natural world. Human beings are not animals. Human beings are separate from and superior to the rest of the web of life. Under the dominant worldview, the only beings who count legally and morally are human beings. And as an unspoken premise, the rest of the natural world is outside of the moral community. Meaning, of course, that other than human animals have no moral or legal standing. The consequence: humanity polluting the planet, extincting other species, and on a dead-end course for itself. To reverse this frightening trend cannot be done solely by legislation or law reform. The roots run far deeper in our worldview. Law and morality absorbed this philosophy, as did other key institutions. To meet the philosophy of deadly separation must be done at the level of jurisprudence, at the level of premises and values of law, to reconnect us to the rest of the earth community. So this is where we come to jurisprudence, or legal philosophy. And I'm going to define that for you as a search for wisdom by studying and evaluating the structure, assumptions, values, and purpose of law. In this presentation, I offer a vision of jurisprudence, an earth jurisprudence, that has the potential to restore the relationship between people, animals, and planet, and to guide the transformation of law and governance for the well-being of the entire earth community. Earth jurisprudence advances the idea that humanity is one part of the earth community, and therefore cannot arrogate to itself moral and legal standing while ignoring the well-being of the whole. As part of developing the environmental and earth courses at Mary Law School, the faculty joined in approving this definition of earth jurisprudence. There are three significant moves here. The first significant move is to shift to earth-centered perspectives on law and governance. The next is to recognize the responsibility of humanity to regulate itself for the welfare of Earth and future generations. Then the definition recognizes some laws do have seeds of earth-centeredness in them to nurture and draw us into the future. But we will also have to imagine brand new ways of thinking about law and governance. To do this, earth jurisprudence invites us to take a critical and constructive analysis of law and to go beneath the surface to consider the structure, assumptions, premises, and values of law. So let's begin our search for wisdom by considering the moral and legal standing of other than human species. From an earth jurisprudence perspective, I have two related arguments to offer. First, the predicate for all meaningful action is at the level of values. This requires the boundaries of the moral and legal community be widened to include other than human species. Second, the purpose of law and governance cannot be to satisfy human appetites today. The purpose must be to protect the entire earth community, not just for today, but also for future generations, not only of human beings, but also for all species and earth processes. Regarding the first proposition, the traditional boundaries of our moral community begins and ends with human beings, and there's a hierarchy within Homo sapiens. That is another topic. Excluded are all other species. Descartes expressed the influential view that humans are masters and possessors of the natural world. Jeremy Bentham and later John Stuart Mill extended the line to include all sentient beings. sentient beings would do just fine without the rest of the world. Since then, scientists and philosophers have advocated varying principles of moral inclusion. Some have focused on the morality of individual animals, such as Tom Reagan, one of the founders of the animal rights movement. Early ecologist Aldo Leopold was less concerned about individual organisms. His focus was on species and ecosystems. To expand the circle wider, Albert Schweitzer considered reverence for life as the basis for ethics. Schweitzer extended this principle to all matter. In Schweitzer's view, an ethical person does not shatter an ice crystal, crush an insect, or tear a leaf from a tree. I submit that our present trajectory of environmental catastrophe and our current understanding of the interrelatedness of all components of the biosphere requires extending the boundaries of the moral and legal community to be coextensive with the natural world. To make this shift, I propose recognizing the intrinsic value of the natural world through a framework of moral and legal consideration. In 1978, the notion of moral considerableness was first used in the environmental context. The phrase was offered to mean falling within the realm of moral concern, being morally relevant, being taken into account in moral decision-making. Because the natural world has intrinsic value, it also warrants legal consideration. Christopher Stone presented the argument of the legal considerableness of nature in 1972. Legal recognition may be given in a number of different ways. A juror person may be granted rights, be given duties and responsibilities, be the recipient of immunities and privileges, or be held liable, all of which are intermediate, operative notions that flow from the broader principle of legal considerableness. Legal doctrines routinely allow persons that are not human beings to participate in the legal system. Among the persons permitted to sue are ships, cities, estates, universities, churches, and not to mention business corporations. Guardians and trustees regularly appear in our legal system to give voice to people and entities who are unable to speak, at least our language. Our system of law and governance is no stranger to complex moral and legal weighing. Our legal system certainly has institutional experience and capacity to provide legal consideration to natural beings and entities. For the second argument, I propose to widen the moral and legal community in a temporal sense. Moral standing and legal protection must extend beyond today to future generations. Moreover, intergenerational equity must include other than human species and ecosystems. A number of arguments support extending such equity to the natural world. I'm going to focus on three considerations. First, the prudential self-interest of humankind requires equity for other than human species and ecosystems. From a practical perspective, equity for human beings simply will not work without including other species and ecosystems. We are utterly dependent on the natural world. People would die without plants and other than human animals. Other species provide healing medicines, for example, to human beings. A secretion from a frog is a key element in a painkiller that has few side effects. Mercaptor, a drug that lowers cholesterol, was derived from a fungus on a golf course in Japan. Cancer drugs that reduce death from childhood leukemia were derived from the rosy periwinkle of Madagascar. Clearly, you would perish without the benefits and setting and embeddedness of the natural world. Therefore, equity for present and future generations of other than human species and ecosystems principle of fundamental fairness. The consequence of industrial development will not be borne by the extracting companies that have degraded the earth. Instead, the consequences will be assumed by generations in the future of human beings, other than human species, and ecosystems. Remote species and ecosystems pose no threat to foregoing generations of human beings. The harm runs from humanity forward. Consequently, the fairness principle mandates our taking responsibility for the present generation's threat to everything and everyone in the future. My third argument, it proceeds from a functional perspective, recognizing that Earth operates according to core principles of interdependence and diversity. For billions of years, Earth has regulated and sustained the biosphere of the planet to make it hospitable for the life forms that have flourished. From an evolutionary perspective, let us consider the respective roles and relationships of Earth species. We may pride ourselves on being the masters and conquerors of Earth, yet other species far outstrip us in time, place, and experience on this planet. We are really the new kids on the block. Some propose that we are the younger sisters and brothers of other animal species. However, to demonstrate a relationship of respect for other species, some have advised that we may relate to them not really as brethren, and certainly not as underlings, but as other nations, traveling together with us in the net of time and place. It is incumbent on humanity to learn from preceding nations of Earth how to conduct our affairs. And in thinking about learning from other species, the author of Winnie the Pooh recognized that a lot of people talk to animals. The problem is that most of us do not listen. So if we were to listen, let us think about what Earth has to teach humankind. Earth, teach me stillness. Earth, teach me joy. Earth, teach us communion and connection. Earth, teach us majesty, how to rise above. Earth, teach us wisdom. Earth, teach us gratitude, staying right-sized. Earth, teach us to let go. Earth, teach us the meaning and practice of enough, sustainability. In this sense, it is incumbent on us to infuse our life and law with Earth sensibility, to co-evolve responsibly with those who have gone far before us, respecting the ancient laws and processes that have brought us privilege and bounty to our species. In conclusion, the mentor of Earth Jurisprudence is Father Thomas Berry, who writes that we long ago abandoned our relation with the planet, and that we need to find our way back to Earth. Other than human species are the bridge between us and the natural world. They connect us back to the reality of who we are and why we are here. The great work of our generation, is to make the transition to what Thomas called the ecozoic era, in which we live in mutually beneficial relationships with other than human species and ecosystems. To make that transition means to shift into ways of thinking and governing that are Earth-centered, embracing approaches such as moral and legal standing and intergenerational equity for all members of the Earth community. Thomas also offers a statement of caution and hope. As we make the transition, we must note that moments of grace are transient moments. Transformation must take place within a brief period. Otherwise, it is gone forever. In the immense story of the universe, that so many of these dangerous moments have been navigated successfully, is some indication that the universe is for us rather than against us. I take hope from the recognition that the universe has long been for us. It is time for human beings, Homo sapiens, the wise ones, to also be for the universe. So I want to thank you for the opportunity to participate in this conference and to share this message of hope and inclusion. Thank you.
I would just like to add really quick, we can also direct questions towards Professor Koons as well. The floor is open to Mr. Wise, Professor Koons.
Oh, yes.
Okay, as Professor Koons, both of you are addressing sort of fundamental shifts of consciousness theory and also law, but how can we address, first of all, these fundamental shifts using the law, which tends to replicate itself in a normative way? And you seem to be saying we're trying to replicate it normatively, and using that normative discourse, rights discourse, how effective is rights discourse to be creating shift in our culture? Versus say, thinking pretty differently about how we want to approach this, such as thinking on a period of commons, or a comedy, or some kind of approach to the environment and to different approaches.
Well,
Both for both Professor Koons and Professor Weiss.
as a practicing lawyer, as I say, law and judges it's very stable. It's very, very hard to make fundamental changes. And so we think that however, changes are made, and the best common law judges know how to do it. Someone like Cardozo, for example, where he might look at an old problem and kind of reshuffle it and say, ta-da, I'm using the old principles, but now I'm doing something new. And that is essentially, we're looking for those kinds of judges. We're looking for Cardozo. We're looking for a Mansfield. We're looking for those kinds of judges who understand what we're trying to do, empathize and sympathize with what we're trying to do, and realize that it is the right thing to do. It's the just thing to do. And one thing I do have a great respect for is that when judges want to arrive at a conclusion, they do. And they will do it however they have to do it. And so if we have judges who accept our arguments, and that's why we're making the arguments in language that they understand, that they were taught, that they deal with every day, then if they feel that we are right, then they will rule in our favor. And I don't exactly know in what direction they will, what arguments they'll accept, what arguments they'll reject, but they will rule in our favor.
I want to say a few words. I have a great respect for what you were doing, Mr. Wise. I think the question that's being raised are what are the limits, though, of the rights discourse? And we can see that very clearly in the civil rights context. That sometimes groups of people will get together and say we need to create some massive shift in the way that we're thinking and acting and behaving. And so they will put all their eggs in a rights basket and go forward. And then the courts and the legislature will deliberate on these. And we will come out with this shriveled up little thing. Okay? So we go into this with these great ideas of shifting ways of thinking and being. And what we end up with is this little remedy that really is very, very shallow compared to the original thought. So rights can be thought of as little bones being tossed to create the impression that we really are creating this massive change. Without what we end up with is not much of anything. However, that being said, I think that the rights discourse is certainly important. Okay? It is a piece of the grand puzzle that we have before us today. There are groups like Mr. Wise's group that's doing such important work. And while he was talking, I was thinking very much of Brown versus Board of Education and all that went into Brown versus Board of Education. And if you watch, for example, Eyes of the Prize, you'll see kind of thought that went into creating, that lawsuit just did not appear out of nowhere, okay? There were legal minds and psychologists and sociologists and a lot of people all across the United States for decades working on what came to be Brown versus Board of Education. But what Brown versus Board of Education wrote on was not simply this little fiction of rights. It wrote on cultural change, because there were other things happening at the time. Many, many other things happening at the time. People were, churches were doing things. Civic groups were doing things. People were being sent to learn about how to do engage in civil disobedience. Mahatma Gandhi, there was this incredible global discourse that was going on. So there were cultural shifts that were happening that Brown versus Board of Education was able to ride on. Okay? I think that we are having the same sort of shift of consciousness now, vis-a-vis earth rights and vis-a-vis other than human species rights. Okay? We're having a tremendous shift of consciousness all across the globe, actually. In fact, that we're having this conference is one indication of it. I have been speaking about these things for the Center for Jurisprudence now since 2006. And when I first started speaking about earth rights, earth consciousness, moral consideration, legal consideration, I sort of had to hide behind the curtain. Okay? Because, and there was hostility. What do you mean? What do you mean? A real anthropocentric perspective. Now I can say these things in class, and there is receptivity. So in the past 6 or 7 years, since I've been speaking of these things here at Berry Law School, I can see the shift of consciousness happening. And so I spread the palette pretty broad. I talked about moral consideration. I talked about legal consideration. Legal consideration meaning that we're going to view non-human species, other than human species, ecosystems, we're going to grant them legal consideration. Now, what this actually means is another topic. Is it going to be through rights? Is it going to be through duties? Is it going to be through immunities? Is it going to be through penalties? But clearly, there has to be some legal recognition given to other than human species and ecosystems. Now, the whole thing, I don't think it's an either-or proposition. I do not, I really don't agree with the either-or approach. Instead, it's all of the above. It's an all of the above. We need Stephen Wise. We need the chimpanzee. We need the elephant. We need the orca. We need all of us. And we need all of these various approaches because that is the way we really affect cultural change. So I'm so glad that Mr. Wise is here with us today.
If I may say, Judge Posner understands what I'm doing. And in fact, he in one of his writings, he accused me of being, quote, a deer caught in the headlights of Brown versus Board of Education. In the Non-Human Rights Project, we have studied that carefully, and the 20 years that led up to it. In fact, I reminded the folks who are working with this. I said, look, as they were re-arguing the case in front of the U.S. Supreme Court, they were working, 24/7 for 2 months. So, don't think about taking any time